Hi, everybody. Welcome to NC Realtors Mobile Monday. My name is Amy Baker. I am now the past chair of the Residential Forms Committee. I just finished up my chairship. Sure, we'll call it that. And a new chair will be coming in. In thinking about the Forms Committee, we had some discussions kind of behind the scenes that we might be one of the committees that, we like to think has the greatest influence on your business, or at least you deal with most often. You guys interact with these forms with your clients. So we want to just talk a little bit about the Forms Committee, who we are, what we do, how we get on it. So I'm going to do a little intro and tell you some things before I hand it off to John Waite, our legal counsel, to tell you about the forms changes. So the Residential Forms Committee is made up about 25 or so members. Members are selected through an application process. Each year it opens up on the NC Realtors website. Usually it's the president who makes those decisions about who gets on the committee. They try to have a balance of about 80% experienced and about 20% new agents. The 80% experience is really important because so many things come up repeatedly. If we've been on the committee a few years, like I have, things will come up in suggestions and we will say, oh yeah, that one has definitely come up. We've already talked about that. We've voted on it. No, we don't have time to take that issue up again. But then those new members are also important because they bring in new, fresh ideas. When members are appointed to the committee, they have a one-year term. We're kind of funky. We're the only committee that runs July 1st through June 30th, as opposed to with the calendar year. People who are on the committee typically meet in person. It's up to the chair. During COVID or bad weather, we will sometimes switch to an online format. But assuming we're going to be in person, we all drive to Greensboro. So once a month for 9 meetings a year, roughly. Sometimes it's 8, sometimes it's 10, depending on what we have to accomplish. We all drive to Greensboro and we spend an entire day there. Usually the meetings are 4 to 6 hours. So it's a pretty big time commitment for those volunteers on the committee. In addition to the regular meetings, a lot of members volunteer for special subcommittees. If we're going to totally redo a form or draft something new, we just don't have time to do it in our monthly meeting. And so some select members will volunteer to do some additional things. Our committee is responsible for about 70 to 75 forms. So we've got a lot on our plate. We don't touch every form every year, but just so you kind of realize, the breadth of what we have to do. A lot of people don't realize that even though our committee has that many forms, there are some forms we are not responsible for. The residential property disclosure, mineral oil and gas, working with real estate agents are the 3 big ones. Those are not under our purview. Those are the North Carolina Real Estate Commission, so we don't handle anything to do with those. Approximately 20 to 25% of our, 20 to 25 of our forms are also jointly approved by the Bar Association. So that means we can't make changes to them by ourselves. We will vote on changes, but then some of our committee members are also on a joint forms task force with members from the bar, and those changes also have to go to them for approval, debate. Sometimes they come back to forms, so sometimes we'll kind of bounce things back and forth, but those members have an additional time commitment with that joint forms committee. The agenda for each meeting is set by our staff liaison, the committee chair, and legal counsel. That usually is set with member suggestions, notes from different associations. The Real Estate Commission sometimes send us things, so we sort of have suggestions for agenda items from a couple different sources. Our committee can edit existing forms, create new forms, or retire or pull old ones that are no longer necessary. While we're in our meetings, we have ideas and changes that are discussed, debated, and voted on. So everything has record of a vote and different committee opinions. Any changes that we make and anything that the bar has to approve still has to go to the NC Realtors Executive Committee. So there's several levels that have to go through before form changes actually happen. So it's quite a process. We don't just make a decision and then it happens. There are other steps to the process. Our goal is to release new forms changes for every July 1st, but every now and again, as we did this past year, we'll do some special releases if something else is necessary. That's it for me. I hope you learned a little bit about the Forms Committee. If you're interested in joining, the application process, like I mentioned, is on NC Realtors website when those are open. I don't know if they are now, but I'm now going to hand it off to John Waite, our legal counsel, and he's going to tell you about some of our forms changes for this year.
Thank you very much, Amy. Yeah, that was a really good overview and rundown, and also a good explanation of the fact that I am not to be blamed for any of the forms changes. It's everybody else's fault. No, no, no. If anything, in truth, the forms committee, the people who volunteer there, they do a really good job of protecting you from people like me. I am not a practicing real estate broker, so there are times where, my dumb lawyer brain will propose something for a forms change, and the forms committee will stare at me and just say, "Listen, we we appreciate you, but that is not a good idea, John. It's just not a good idea." So appreciate all their time, effort, and energy that they put into making sure the forms work well. Um, Again, my name is John Waite. I'm with Martin and Gifford in Winston-Salem, General Counsel to NC Realtors. My job on those committees is just to try and help facilitate the language to propose to the group to try and, when you got that many people having a lot of different ideas about forms, then sometimes, for me, it's just trying to synthesize those ideas and put them into one cohesive thought that everybody can try and agree on. So we'll go through some of those today. A lot of the stuff I'm going to cover is actually located here on the ncrealtors.org website, which you can see here under the legal Q&As. You can see summary of forms changes, and you can see actually quite a few years worth. If you go over here, you can see these categories. You got here summary of forms changes. And a lot of what I'm going to go through is actually in the residential forms here, but you can see these go all the way back to 2021. And you see commercial, residential, auction, whenever they come up, that's where they're located here. And when you go to these Q&As that do a summary of the forms changes, you can click on these hyperlinks. And the hyperlinks, you can see the explanation here, but then the hyperlinks take you to the form itself where you can see the edits and guidelines. So we're going to start with Form 2T and talk about that. Form 12T, the vacant land offer to purchase a contract, also got a lot of the same edits. I'm not going to cover that today. But if you want to see the actual strikeouts and everything, that's in the 12T hyperlink in the Q&A over here. So down here, if you click on the 12T, where's 12? Where's 12T? Anyway, it's here somewhere. Anyway, the 12T vacant land offer to purchase and contract has the actual strikeouts and everything. This version here of 2T just has highlighting to show you, that something has been changed, but not necessarily where exactly the change came from. So the biggest change that happened to the offer to purchase is that the blue boxes and the red boxes that were notes and warnings, those have been removed from the boxes. You won't see any red or blue boxes in the form anymore. And they've been incorporated into the contract itself or moved to the guidelines, which I'll talk about in just a minute. So, Forms Committee had a pretty robust discussion about what actually needs to be in the contract as opposed to what is already in, right? So we're going to go through a few of those today. And the real focus of doing the refresh on this particular form was trying to make it just easier to read, more user-friendly, and it is a little bit shorter. Let's see, I think it's 14 pages. I think it used to be 17, so about 3 pages shorter than what it was last time. So let's take a look at the first page here. You can see you got, the parties, you got the property address, and then down here at the bottom, you have now seller concessions, due diligence period, and the settlement date. Escrow agent is still here on the second page, but we'll keep working on this form throughout the next cycle, just because we want to try and get everything on the first page that's of the most importance to you guys. And certainly that's something that you probably want on there. The other thing too is, in case you haven't heard yet, I guess I'll just spoil this now, is that there may be some more changes coming to this form pretty soon because the General Assembly's passed a statute that now allows agent compensations in the contract. So Forms Committee's got to look at this and see how that may fit into that, how it fits in with 220. They got a bunch of difficult things to wrestle with in that, but I feel very confident that they'll be able to figure out a way to incorporate that new rule. The Real Estate Commission has already proposed their rules change for that particular statute, but the statute, the way it reads is that it's actually in effect right now, like today, even pending the rules change from the Real Estate Commission. So that might be something where if you're looking for sort of an immediate thing on that, talk to your favorite closing attorney about it, get input from them, maybe look at a custom addendum while Forms Committee has a discussion about how the rest of the form should work. But for now, as you can see, as of right now, for these everything I'm going to talk about today came out July 1st, last week. So you should be in zip forms already, without the highlighting, of course. And then it's also available on the website. Over here on the website, you can see if you hover over legal and ethics over here, forms library, it's right there. All right, moving on down in this form. This change here, it doesn't look like a big change, but it is in fact kind of a big change. So under the previous version, uh, it really made it sound more like that there may be a written agreement that's mandatory in order for an escrow agent to be able to release earnest money. But that's not what the law is, honestly. The law is more concerned whether there's a dispute or not about escrowed funds. And so this language is actually different than what used to be here before to hopefully give escrow agents a little bit more flexibility on how they choose to disperse escrow, earnest money deposits. And you can see right here in this language right here, it says in the event of a dispute between buyer and seller over the disposition, et cetera, et cetera, et cetera. And they might need to do these other things with the clerk of court. If there's no dispute, there's no dispute. Whether it's written or whether, if you got a buyer or seller's just disappeared. A lot of times in those scenarios, when people call the legal hotline, the NC Realtors legal hotline, say, hey, what do I do? This, buyer or seller's disappeared. Sometimes I'll recommend that, send an email to the other agent, say, hey, unless your client claims the earnest money within 48 hours, then we're going to presume there's no dispute about this earnest money. And then it's up to the escrow agent to decide whether that's sufficient or not. Now, not every escrow agent is going to accept that. Some of them, they can, it is money and trust. And you guys know, any of you that deal with trust funds know that it's a serious decision on how you decide to approach trust money and whether and how to disperse it. So some escrow agents may still have the policy internally. Listen, we don't let it go unless there's, a written agreement. And if there's no written agreement, then, figure it out in court, or at 90 days, we'll send it to the clerk of court or whatever. Okay. But in some scenarios, hopefully softening this language a little bit will help you guys in those scenarios where a buyer or seller has disappeared, you can't find them, there's no real dispute about the earnest money for one reason or another. And maybe you can convince the escrow agent to let it go to your client without having to do a court action. Down here, this used to be in a red box. You can see now it's just part of it. The red lettering will still be there when it's, all said and done. Just the highlighting will be removed. So if you see lettering in red, it will continue to be in red in the form, hopefully in order to make it stand out a little bit, but stand out in a way where it's more readable. Here in fixtures and exclusions, you can see red language here. It says the party should not assume that an item will or will not be included in the sale based on a statement or advertisement outside this contract. That's really to hopefully give you a little bit of cover, maybe highlight to the client a little bit to say, hey, just because it's in the MLS listing, if it's not in here, it doesn't exist. So, make sure that they're aware of that, and make sure that especially if you're a big of a firm, that you make sure your agents cover that with the clients. Down here, these bullet points, there's nothing earth-shattering here, nothing really big. These bullet points, just the reason they're highlighted is because they're made to match the new exclusive right to sell listing agreement that came out in January. This July 1st rollout is, as you guys know, the actual third rollout of forms changes this cycle. So if it's felt like it's just been a fire hose of forms changes over the last year, you would be correct. And it's not because, Amy and I just sat around and trying to think, how can we ensure job security and also to make sure that we make people's lives as difficult as possible, doing as many form changes. It's not like that. Okay. There's no plot. There's no conspiracy on that front. Really, the previous forms changes were done because they needed to be done. And a lot of the focus is just making sure that they are easier to read, easier to understand, and just address the market in a way that reflects better things post settlement. And that includes this contract here. This is a complete overhaul of some of the structure of this contract to make sure that it's just easier to read and understand. Now, is that job done? Yeah, I would say probably not. But is this a big step in the right direction? Yeah, yeah, I would say it's a big step in the right direction. And Forest Committee will have to continue to look at this form, with that lens going forward. In any event, um, moving on down as far as technical changes to this form, you've got any items leased or not owned, make sure they do a custom addendum. So if you got solar panels or things like that, that the seller really wants to have, the buyer take over, unless you get a custom addendum for things like that, then the seller's expected to pay off any liens at closing. So make sure you got a custom addendum if you got a seller who feels strongly about that. Personal property, you got a little bit of language there that I can't remember if that used to be in a note or not. It might have been. But in any event, make sure that you remember if you got a lender that doesn't want personal property in this particular paragraph, then you have Form 320-T, which is the agreement and bill of sale of personal property. You can use that instead. Here, you got a little warning in red that the buyer is strongly encouraged to conduct due diligence during the due diligence period. That, if you didn't know that language is in there already, it was. Now it's in red to hopefully highlight it. Then in 4A here, you got a little italicized language here. There's no loan or appraisal contingency in this contract. And a reminder that, if the buyer does want that kind of contingency, they're going to need a custom addendum. Same thing down here. And actually, let me pause on this language here in red in the middle of the screen, paragraph 4H. It's a pretty common hotline call that I'll get where, an agent will say, hey, how do I make sure a sale is as is? And I tell them, well, every contract, unless you attach a custom addendum, already is as is. And it's because of this red language that's right here in paragraph 4H. So now it's bolded, red, middle of the page. Hopefully it stands out a little bit from everything else to make sure that clients are clear that whatever's in this contract, that's what it is. And there's not going to be any changes to the property unless there's other provision made in writing. Here you got buyer representations that their obligations under the contract are not conditioned on any loan. That used to be part of a note, if I remember correctly. So it's just moved into the regular language of the contract. Down here, same thing, I think, with this cash section. But down here, this is actually a little bit new and a little bit of an addition to what's already out there. It might be something that Forms Committee will decide to stress a little bit differently later this cycle, or maybe they'll leave it the same. I don't know. That'll depend on input from you and from them. But it says this subparagraph is only a disclosure by buyer and does not make the contract contingent. So that's how this contract has always been. Some of you have been practicing a while know that there used to be a thing called a contingent sale addendum. I can tell you I've been getting hotline calls about wanting a contingent sale addendum. There is not one right now. And depending on feedback from consumers and from you guys, it might be something that Forms Committee will look at again next cycle. For right now, there's not a form for a contingent sale addendum. But if it's something that you really want, then it's certainly something that your favorite closing attorney, you can ask them and they could do, make you a custom addendum if you want one. Down here, you'll see under buyer obligations, you'll see language that used to be at the top of page 2. But now it is down here and it's been simplified a little bit. But if the buyer doesn't pay money on time, then the seller needs to make a demand. And here in Romanet I, you can see that there's a reference to Form 355. That's the form that you can use to make a demand if you wish. And then once the demand for the money is made, then the buyer has one banking day to pay the money, or the seller will have the right to terminate. The interesting thing is this language down here at the very bottom, right before the signatures, this offer shall become binding unless provided otherwise, regardless of the delivery of any fee, deposit, or payment. So it's a pretty common question on the hotline of, hey, the buyer hasn't paid the money. Do we have an effective contract? Yes. Yes, you do. As up here is the definition of effective date. It is on the second page. Whenever the last one of the buyer or seller communicates acceptance that they've actually signed, then that is the effective date of the contract. You don't even have to have an executed copy of the contract to have an effective contract. If it's a scenario where the buyer has signed, they send it over to the seller, the listing agent tells the buyer agent, my sellers have signed. That's it. Even if it's just like a text or an email. It could even be a call, something like that to communicate that there's been an actual signing by the other side. That is technically the effective date. Obviously, if you're doing a phone call, then that could lead to fights. Please don't do that. Make sure you communicate that in writing so that everybody has a timestamp of when the contract becomes effective. But that's the effective date, regardless of whether or when you get an executed copy of the contract itself. Okay. Moving on down, we've got seller representations. And in the seller representations, you've got something here that talks about ownership of the property. The lead-based paint is not actually new language. That language is really just, that was already there. The reason it's highlighted is now it's pulled out of a warning box. So it's one of those scenarios. Down here, I'll make a note, now you have Association 1 and Association 2. And the reason for that, otherwise the rest of the stuff is the same. But the reason for that is just because you don't have to fill out that information twice. You guys are already papered to death, okay? Nobody's trying to paper you more to death. If anything, there's a lot of focus on making sure you're not having to do more paper than necessary. Don't feel like you have to fill out, the same association information twice just because there's two blanks there. If you got two different associations, fine. But otherwise, just one time will be sufficient. All right. Moving on down, we've got some new language here about settlement deliverables. And this is actually, Romanet I is actually an addition, and it's because if you're not yet in a county that has electronic filing, everybody's going to be on it really soon. In fact, it might be this week where everybody else is going to get on it. Maybe it's still just some counties. In any event, I mean, that switch over to fully electronic filing in North Carolina's court systems is going to be complete pretty soon. And the issue is, like, say you're an attorney looking, if say I'm selling my own house, right? And an attorney is looking to see if I got liens or judgments against me. In the new electronic filing system, it is very, very, very difficult to figure that out because, and I know this will shock you, but attorneys mess stuff up all the time. I don't know if you guys knew that or not, but we do. We are not infallible. I know it's going to be a shock to everybody on this call. In any event, as you might imagine, sometimes when lawsuits get filed, the chances of a name of a party being misspelled are really pretty good. I mean, I would say it's in a majority of the lawsuits I've seen over my career, over my, I would say it's been a majority of the lawsuits will have at least one name that's spelled incorrectly. Well, you can imagine when you're searching for a lien, this creates a nightmare because a lot of times that's not fixed. Not when it comes to the actual, like, digitized file. Where is this thing stored? What name it's under? No, I mean, it's going to be something where you would, if you were looking for a lien against me, you would need to look specifically under the way, the way it's spelled on my screen, John Waite. Okay, fine. We can do that. Waite, comma, John, John. But then you'd also have to search or know to search or figure out some way to search. All right. John, Jon, wait, Wait, John, Jon, wait, Waite, John, wait, Wait, right? So there's any number of permutations, even for my little name, that you can figure it out. And Lord help you if you've got like any sort of complicated name or a hyphenated name or just a two-part first name or last name, you see them going. All right. That's what makes searching for these liens so hard for lawyers right now. And so what they want is an affidavit and indemnification agreement from the seller saying, hey, if we miss it, then you're still going to be on the hook for it. Okay. You're sorry, but that's only fair to the buyer. And that there's got to be something there to assuage them that if there's going to be some kind of lien issue, that the seller's not, they can't just run away with the buyer's money and not be held accountable. Same thing for the lawyer and the title insurance company. They don't want to bear the full burden of that either. You know, not it may there may maybe not quite as maybe shouldn't bear quite as much responsibility as the seller necessarily, but they do have a job to do, and they're trying to do it the best they can to try and give warranty of title to a buyer. And so that's why this is in there. A lot of you are already complying with this. Probably most closing attorneys already are making sellers do the paperwork for this. This language has just added it in to make it more clear. So if you run into a seller who's asking you what in the world is this, seller settlement deliverable paragraph about, that's what it's about. All right. Moving on down, let's see. I don't think there's anything else that's hugely a big change in this. I am going to take a minute to kind of get off script a little bit regarding forms changes and talk about this section here. The wired fraud warning language has been updated to hopefully make it just a little bit easier. It used to be just kind of a big block, and I'm not sure how many people were actually reading it. However, I do want to just take a minute and stress very, very, very strongly while I have all of you hostage here on the line that you need to be extremely vigilant about scams. That includes wire fraud scams, it includes fake seller scams, and it includes buyer scams. Now, let me just briefly talk about each one because, and I'm not kidding, last week on the hotline, um, you know, Adam and I were talking. I think we talked to 5 agents, and these agents were calling because they wanted advice on forums or something else. And it wasn't until we started asking questions about this particular seller that they even had any clue that they were in the middle of a scam. So I'm going to take a minute on this because it's just too important. And it's apparently just so rampant right now that you just need to be aware of it. If you have a seller who's out of state or out of country, whatever, and it's vacant land especially, then you need to assume it's a scam. Just assume it. Maybe it's not. I mean, that's fine. But you need to assume that it is. And if you are not going to insist on meeting the seller in person, then you are going to have to do a significant amount of legwork to positively identify that the seller is actually the seller of the property. One of the things that's here, the wire fraud warning, and the reason I bring it up, and because this language has been there, but now I think it's more important than ever, not just for wire fraud scams, but for all these different scams, is that if you got a seller, you know what their name is on the deed. Okay, you've got names, and what you should do, along with a lot of other stuff that I'll cover in just a second. But one of the things you should definitely do is look at those names on the deed and reverse engineer the contact information. Whatever contact information you got from the prospect, you need to assume is fraudulent if you haven't seen their face. That includes the ID. That includes whatever other documentation they're giving you to try and prove that they're a real person. They are impersonating all that stuff. And now, with AI the way that it is, and with how much advance it's making every single day, it's already possible for somebody to hand you a fake ID over, just email you a copy of a fake ID, and then also have AI, even on a FaceTime live call, impersonate that face on that fake ID. It's already possible. It's already happening, not a ton, but I imagine it's going to become a lot more prevalent especially if scammers figure out that your main go-to, if you're not meeting someone in person, is, oh, they just want a FaceTime call. We can do that. We can, make your face look just like the ID anyway. All right. So a really important part of this wire fraud warning that's also something you need to be incorporating into sellers you're not meeting in person is look at the name, talk to neighbors, look at social media, find a, contact information that is completely separate from whatever prospect, referral source you got it from. Okay. When it comes to the buyer scam side, yeah, that's a little bit different. That's pretty much still remains mostly a confidence scheme where you got a buyer who's talking all about how much money they've made in crypto or gold or stocks, whatever, right? And then what they want to do is like gain your trust because they've got all this money and they're buying all this cool real estate, doing all these cool things. And what they're relying on is for the agent to get FOMO and then want to invest in them and then direct you to a website for you to invest your money, and then suddenly they disappear with your money. Okay. That's how those confidence schemes run. They've been around a long time in a lot of different ways. But if you're listening to me talk right now thinking, well, those two things sound dumb, okay, well, first of all, stop being judgy. Why are you being so judgy? No, I completely understand where you're coming from. But let me just throw this at you is that, I'm married to my wife for about 20 years. She's very smart. She owns her own store. And a couple of weeks ago, she was this close to going to Walgreens to pay her electric bill because supposedly Duke was coming to turn her power off. Okay. Now, why did that happen to this person who I know for a fact is extremely smart and capable? Because she's like you, she's juggling 17 different things. And when you're doing that, you don't always have the clarity of mind, that you need to be able to spot something like this. That's why, especially if you're a BIC, you need to have procedures in place for your agents to make sure that they are ticking off some boxes before they're just running headlong into some kind of fake seller or fake buyer scam. All right. Anyway, thank you for indulging me on that. But it's one of those things where, as part of forms update, sometimes I like to, cover these things, to try and cut off some hotline calls. Thank you. All right. That is Form 2T though, and the big update on that. As I said, the vacant land contract, similar refresh. I'm not going to cover that today, but if you want to look at it, it's there. The guidelines to Form 2T have also been updated. I'm not going to cover these in detail, but you should definitely look at them. As I said, a lot of the notes and warning box stuff that got moved to the guidelines, but also there's some stuff in here from Q&As. So for example, here in paragraph 2A, when it's talking about fixtures, because 2T has two different ways something can be a fixture. It can be a fixture by common law, or it can be in the bullet points. Either one of those two things is going to be a fixture. Well, the common law test is right here. So if you need to be able to cover that with a client, then it's right here for you to be able to look at. So at your leisure, go ahead and take a look at the guidelines to 2T. They've been updated substantially and should be able to help you as you're going through things like that with your client, those specific scenarios. Here you can see we got the buyer possession for closing agreement up next, and the small edit to this one, and this a similar sort of edit was made for buyer possession, seller possession, and on the additional provisions addendum, basically making it very clear when the seller needs to unpair their smart devices and make sure that they're not, recording people on the property or whatever, right? Just basically disconnecting themselves from the system. So in this form, in the buyer possession form, they got to do it prior to the commencement date. In the seller possession form, they'll have all the way up until the seller actually leaves, right? Because the seller's in possession after closing. So they guys just got to do it when they get out. And then for additional provisions, a similar change there for that. So I think that's for the landlord-tenant context, maybe. Can't remember exactly. But in any event, it's about the seller unpairing their devices. Here we have the agreement to amend Form 4-T, and you can see here we've got removal of a buyer seller. I imagine this cycle, we will talk to the Joint Forms Task Force and the closing attorneys on there about, doing an additional seller maybe up here in this section. We will see. But for right now, removal of buyer seller, you can do either one. And if you need an additional buyer, this change was made last year. That overall has gone very well. And so I think it's one of those things that, as you continue to use these forms in a prudent and wise manner, then we will continue to trust you with more keys to the kingdom. I'm just kidding. It's not like that. It's not like that. But Forms Committee does have very robust discussions about, listen, okay, well, we understand this could be a good idea, but is this something that people are going to be able to handle? Risk management is definitely one of the things that Forms tries to accomplish and tries to do its best to make sure that, um, especially you brokers in charge that have a lot of agents, you need to make sure that the forms have some protection, some guardrails to make sure you keep all your agents in line as much as possible. Anyway, you guys know you guys know a lot more about herding cats than I do, so I totally understand and get where you're coming from. Here we got a small change on the due diligence period for the agreement to amend. And the expiration date here is the extend through. So now just by taking out those two words, and I think this actually came from Amy. This might have been Amy's idea, I'm pretty sure. In any event, obviously Forms Committee agreed with her on it. And by taking those two words out, you can now shorten the due diligence period or you can extend it, either one. So you just changing the date. And so now that's something you can do in this. Moving on to the exclusive right to sell listing agreement. As most of you know, this form was rewritten in January this year. And so these July 1 changes are just to the existing form. One of the things you have here in the marketing section is the multiple listing options for sellers policy. In response to that, these changes are coming into place now just because we don't know what all the MLSs are going to do with that, with that new marketing choice. It may vary MLS to MLS. Just as a general proposition, you can know that the multiple listing options for sellers, like the delayed marketing, the new option that's in there is basically sort of in between public marketing and office exclusive, where a property will be put into the MLS, marketed to participants in the MLS, but that's it. It doesn't go through the wider syndication. So I'm not, I don't, however MLSs decide to treat that, there's a lot of different options for them. So that's why, I think for a lot of MLSs, they're trying to figure out how to approach it is a difficult process. So we're waiting to see how that sort of plays across the state. As far as Form 105, you can see here on the screen, that's the internet advertising addendum. Not very many people are using that. And because so much is going to be changing in response to that new rule, the form itself has been retired from the library. If you got something else that needs to be special for general advertising in the internet arena with your seller, then just put it in paragraph 19 below. So that's later on in the form. All right. Moving on down to this section here, you can see we got some changes here. This is something that I do want to take a moment on just to, try to make this as clear as I can. Obviously, this has been, quite a few hotline calls on this section because this 7B and 7C work differently than the old forms. So obviously plenty of questions on that. That's, totally reasonable. If you still got questions on it right now, you're still reasonable. Like there's just been plenty of questions. It's obviously a big shift. But one of the things that I want to say is, I've been getting some specific questions about, well, can I do it this way? Can I do it this way? And the answer, generally speaking, to just about all those is sure. I mean, that's what this box here is. You can do your fee schedule, just attach it. You could put NA on both of these sections entirely and just have your own complete thing. That's fine. The one thing I do want to say about, making sure that your firm's fee, what your firm is going to earn, and your firm alone, what are you going to be paid? The reason that's important to have as a separate discussion from anything you might be paying potentially to a cooperating agent is the discussion with the seller. And that's what this is designed to facilitate. It's not designed to just be here to be more cumbersome. That's not the point. The point is that, North Carolina's forms have always tried to be as forward thinking as possible. They've always tried to be as communicative to the consumer as possible. And the thing is, when you are just under the old form, especially once MLS rules were no longer, operating this way anyway. But under the old form where you were just, where you just had one amount and then you were sharing whatever without really communicating to the seller necessarily exactly what that was going to be, or maybe a better way to phrase it is sometimes that discussion just was not as thorough as possible, or as it could have been, I should say. And that's not to blame anybody, or throw stones or whatever. And I'll give an example of that in just a minute. But to the larger point, you want to make sure that your seller is understanding that your firm is going to be paid something, and then if they want to offer essentially what's a concession, to a buyer and their agent, then here's the terms on which you do it. And making sure these are two separate things is a very good way to just make sure that you, as a firm, are having the communications with the seller to make sure that a seller doesn't turn around and have an argument of, well, my agent didn't tell me that. Because in a lot of these antitrust lawsuits, whether they're on their seller side or the buyer side, almost all of them will have an allegation in them that says, I, the consumer, did not understand what my firm was telling me. And because of that, and because of the way it was structured, then it's therefore an antitrust violation. This, having it separate, is a way to make sure that that discussion is as robust as possible. Why does it need to be? I will give you an example. My in-laws just sold their house here in North Carolina. They have, my father-in-law, he's retired Air Force, and so he's bought and sold dozens of houses in his lifetime. Okay. This is not somebody who's not, it was not their first rodeo. And so it was very interesting to me. And by the way, they had a listing agent who did an excellent job. It was really interesting. I was sort of like a spy, just like listening to my in-laws relay their discussions with their listing agent. One day I'm going to meet this listing agent, and she's probably going to be, oh my goodness, I can't believe that. Anyway, they did an excellent job explaining things to my in-laws, and really did a good job of explaining, in particular, the difference between 7B, what the firm was going to get, and 7C, what potential cooperative compensation might be offered to a cooperating agent. And so that part actually went a lot more smoothly than the next part, which was this. I had to have three different discussions with my in-laws about the difference between a due diligence fee and an earnest money deposit. And I'm not talking about short conversations. I'm talking about three separate 20-minute conversations on due diligence fee versus earnest money, how they're non-refundable, how the due diligence fee is non-refundable, when the earnest money goes hard, things like that. We in this space, we just deal with these things every day. And so I think it's easy for anybody, once you really become comfortable with a concept, it's hard to understand how people might not understand that same concept the same way or in the same depth. And so I think it's good, if nothing else, to just have a little reminder and reset about, not just earnest money due diligence fee, but also on firm's fee and cooperative compensation. Make sure that the conversation is as robust as possible and the seller understands that they're two separate things. If your firm wants to structure things, differently, then of course there's other fees right here. You check the box. If you got other fees for dual agency, if you've got, unrepresented buyers, things like, if you got a certain way you want to do your fee in those scenarios, you can put it here. Again, make sure it is a clear discussion with the seller about what exactly your firm expects to be paid. Moving down, you can see a change here on total cost. It's now just optional. Obviously, if a listing firm has a bunch of different fees, like if you're charging one thing for an underrepresented buyer, one thing for dual agency, another thing for a cooperating agent on the other side, if your firm's fee is different all around, then this total cost line probably would end up being some kind of range. I don't think that's impermissible. You could also just do something like C above. You could put something like that there. In any event, it's just instead of doing this, calculation here, which doesn't really make sense if there's a bunch of different fees for firm's fee. I mean, just having it being an optional line. And so if you want to put it in, you can, you do not have to. Here you got transfer of interest to in business entity. This is just rolled over from the previous form. If you got a seller who, instead of doing a straight up purchase, they do a transfer of business entity, making sure that that'll trigger your ability to get your commission. Here on dual agency, this change is just to make sure it matches exactly what's in the exclusive buyer agency agreement so that they're not two different things. That was my fault. I will take ownership of that. Sometimes, sometimes I'm just not perfect. I don't know what to tell you. Sometimes I'm just not perfect. Same thing here with inspection costs. Yeah, I apologize, for the previous version. Me and my lawyer brain, to me, the buyer was never a party to this agreement. This is the exclusive right to sell listing agreements between the seller and the listing firm, right? So to me, I always felt it was unfair whenever I got phone calls from a listing agent who, they've sent their plumber to the listing in order to get the property ready to sell, or they've had a survey done. They've gone above and beyond for their client. And then the seller, decides that they don't want to be, list their property anymore or whatever. I always felt that it was very unfair for that vendor who, in many cases, you've spent years, cultivating a relationship. And then now they're looking at you being like, well, are you going to pay me? Because right now your client says they're not paying me. Well, that's just not fair. And that's what always what this section was about, was to make sure that, the seller, if they tell you to go use one of your connections, that they are going to be bound to pay for that inspection or, survey or whatever. Um, so that's what this paragraph, all these edits are meant to make more clear. However, to be clear, under the old form, still the case. Even if you've got an old version of this form, it's not about buyer inspection costs at all. So hopefully these edits will make that more clear. And I apologize for the previous phrasing if it caused you any consternation or difficult conversations with your sellers. Yeah, no, yes, apologize. Sorry. Seller estimated net sheet form 110. Obviously, a big change to this form. Big shout out to the subcommittee that worked on this. A lot of edits to this form. You can see the whole thing is in yellow. It's still one page though, but a lot of the edits to it have hopefully make it a little bit easier to have discussions with your seller clients and compare offers. Here you can't see this in white, but this says pre-marketing expenses, then mortgages and liens, and then closing expenses is the third one. So that'll be easier to read on the actual form when it's not in yellow anymore. But it's highlighted in yellow just to show that there's a change. But the whole form, a lot of, I mean, it was a long, I mean, man, there was like 3 or 4 meetings on this form to rewrite it. So I thought they did a good job with it. A lot of really good discussions, and hopefully it'll work up a little bit better than the previous version for you guys when you have that discussion with the seller. Moving on to the exclusive buyer agency agreement form 201. Here, you've got fee for services, a couple of changes here. The biggest one being is that there's now a checkbox for bonuses, and make sure that it is a specific amount. Okay. So when it comes to, your agreement with your buyer, you can getting less compensation is not an issue. So if you say a certain specific amount and then you end up charging less, or there ends up being less, paid as cooperative compensation, you're willing to accept that. All that is fine. That's not really an issue at all. But make sure it's a specific amount. So when it comes to a bonus, understand that you're putting in your ceiling and that's what you're agreeing to. And if it ends up being more than that, then no, that's not something that, unless the amendment to the buyer agency agreement complies with the settlement, then you're just not going to be able to get more than what you put in here. Getting less than what you put in this section, that is not really an issue. But getting more, that becomes a serious issue that you're going to need to discuss with your BIC. I'm not going to go all into that today. There is a Q&A on that I think think it came out in February. Now I can't remember. But there is a Q&A on the ncrealtors.org website. If you need information or a link to that Q&A, then we can send it to you. You can email the hotline, which is legalhotline@ncrealtors.org, or you can call the hotline and we can direct you to it that way. But adding that in, hopefully, and also just to make it more clear, sorry, unless otherwise indicated below, the reason that language is added is the only reason the bonus comes into effect is if it's paid, offered, and paid by the seller or builder. So if it's not offered and paid by seller or builder, the buyer's not paying it. So it doesn't fall under this part here where it says buyer agrees to pay firm. Okay, making sure that the bonus is strictly, purely, a bonus that is paid and offered by the seller or builder. Okay. And here, yeah, so this paragraph here, mutual termination required, it was one of those things where it was actually more appropriate to move this down here. So it's been moved down here and hopefully simplified to make it clear. For whatever reason, I've been getting plenty of hotline calls recently about how do I fire a client, whether it's a buyer or a seller. And here's the thing is that, if you're going to terminate this agreement by consent, then yeah, you need to have a writing, okay? Like a writing between you. Form 720 is out there you can use to terminate an agency agreement if that's what you wish to do. But the interesting thing is that under the old form, if you recall, if you ever had any sort of time to try and enforce those old agency agreements, there was like a mediation required and there was like special circumstances and all this other stuff. And honestly, a lot of times when agents would come to me with issues with a client not paying, they'd already messed it up with the mediation. It was just almost always a mess. And so to me, it just made more sense to propose to the forms committee that to listen, just say, hey, this is already something, there's a simpler way to do this, and that's to just let contract law, do its work. Under contract law, if you got a client who's breaching your agency agreement, and the most common way that they do that is right here, this word, they just don't cooperate with you. If they're not cooperating with you, being so difficult that you can't do your job, or if they're telling you that, hey, I don't want you to be my agent anymore, things like that. Those are all breaches. They're all likely material breaches. Well, down here, it doesn't really talk about that because under contract law, if one side is breaching a contract, the other side is entitled to make an election. Do I, and that election could be compensated for the breach, to be put back in the same position had there not been a breach. In some instances, specific performance, things like that. So all those options are out there and available to you if you have an issue with a client who's in material breach of an agency agreement. And you may choose to do nothing. You may choose to just let them go, let them do their thing, and that's fine. That is perfectly understandable. There might be other times where you think, okay, you want to tell me that, I'm not your agent anymore. That's cool. I still expect to be paid, and I would say that there's any number of options and ways that that can be addressed, but understand that forms, especially these forms, they're not designed to stop somebody from doing something. No contract is. No piece of paper can stop somebody from doing something if they're intent on breaching, a contract. Really, the goal is that, or one of the goals is that, if somebody doesn't do what they said they're going to do, then when it comes time for the form to end up in court or in front of a judge or jury or whatever, that the form does what it's supposed to do, and that's to be readable and understandable. And that's maybe another thing I could have said earlier, but I'll go ahead and just throw it in now. Part of the reason, just one of the reasons that you had, a forms release in October as well as January, is that those of us who've litigated these forms in court know that it is common for a judge to misunderstand the form. It just is. And it's because they don't work in this space. Like, if you got a judge who has experience with these forms in this space, that's rare. I actually did have a form. All right, it's not form. I did have a judge one time for a jury trial who actually had his broker's license. That was entertaining. I'll tell you what. That was interesting. And in any event, especially those of you that do any property management, you know how common it is for a magistrate to completely misunderstand something in one of these forms. And so, it's not just consumers and brokers where simplification of the language and simplification of the form, shortening the form is beneficial. It's also beneficial if the form needs to be, ends up in the middle of a fight that's able to be interpreted and read by both sides in a way that achieves, a just outcome. So it's just a side note, but as far as this section goes for this change here, it is meant to make it simpler. And if you've got a client that's in breach, or if you're the one that's in breach, then the consumer and the broker, the firm, they're going to have the full range of options under contract law to be able to pursue remedies for that particular breach. Okay. Moving on. One of my favorite changes this cycle, and big kudos out to the forms committee being open to this idea, but we are now going to go from 6 termination forms for the contracts down to 3. Okay, so all the termination forms now work for both 2T, the offer to purchase, and 12T, the vacant land offer to purchase. You can see right here, this is form 350, so that's still here in the library. Form 351, 353, and 391 have all been eliminated, okay? So you got 350, 352, and 390, and we'll go over each one of those. But here at 350, you can see it's substantially the same. You got 2 boxes here, one for 2T only, one for the vacant land offer to purchase only, right? So you got that, but otherwise, pretty much the same. Interesting, there is some new check boxes here for the buyer where the buyer can agree to release the earnest money deposit to the seller. And then you also have check boxes down here for the seller. But otherwise, seller reserves all rights to dispute or challenge whatever the buyer has set up in these boxes. Even the seller releases the earnest money. They don't have to agree with any of that. Okay. So as you can see, this is still pretty much substantially the same, but a lot of good small edits to it to make it work for both the offer to purchase and vacant land offer to purchase. Same thing with 352, which this one's from the seller to the buyer. If you ever wanted a list of all the times the seller is actually entitled to terminate, it's these 4 boxes right here. There are a few. It's not that the seller never has the ability to terminate, but it's pretty rare. As you can see, like there's quite a few check boxes here for the buyer, and then the seller has these 4. Now, if the seller wants to terminate without giving a reason, or say the buyer's breached, those boxes are still here, but they need to seek legal counsel. Make sure you're reminding them to seek legal counsel and don't just rely on the form. The form is meant to help do that for sure, but as an extra, whatever, just make sure that, before your client does that, be like, are you really sure you don't want to talk to a lawyer? You might want to really do that, because if they're checking one of these 2 boxes, they may end up, breaching the contract themselves. And so it's something where they really want to make sure they're sure on that. Down here, you got the release of earnest money for the seller. Since this is from the seller to the buyer, so there's not check boxes for the buyer on this one. All right. All right. And moving on. So this is new Form 390. Now, it used to be Form 390 was the agreement to terminate with the release of earnest money. 391 was the agreement to terminate, but there was no release of earnest money. So how do we merge those together? All right, so let's look. All right, so here you got the contract. Here you got the termination language in paragraph 2. Paragraph 3, you got the legal release. Now, this is pretty important because this is not in the other unilateral termination forms, okay? It's not in there. So make sure that that you are aware of that. This agreement, to terminate, it's really something where you've negotiated the agreement to terminate. You've got an agreement in principle. You've got the parties on the same page. The earnest money is going to be split somehow. There's going to be a refund of inspection costs or something. You fill this out and then have everybody sign it. If you can't get an agreement, don't send this form. Don't send Form 390. send one of the unilateral termination forms. There's no release in either one of in 350 or 352. There's no legal release in here that lets anybody out. It keeps everybody's rights the same. And that's not true for Form 390. 390 is meant to be something where if everybody signs it, then you're going to go away and leave me alone forever. Okay. And that's how it's supposed to be. So here in paragraph 4, you have the earnest money deposit in Form 390. And the buyer and the seller either do or do not agree on how the earnest money deposit should be dispersed. If they do, then you're going to fill out here because it says if the parties agree, and so much goes to the buyer and so much goes to the seller. Easy enough. If the parties do not agree, if you check this box, then paragraph B is going to kick in. See, if the parties do not agree. Then basically what this language says is that the buyer and the seller retain all the rights they have under the contract. So then you can go through, say you got other terms, termination, you got this release and everything else, effective date, all this other stuff. Then, sign at the bottom. So what is this down here? You do not fill this out. If the parties do not agree, then you don't fill this out right away. Instead, what this is buyer and seller have now reached an agreement as to the earnest money. They couldn't do it at first, so they all signed up here, but now they have. So this really only comes into effect if the parties do not agree, but then they later agree, then you can fill this section out and then the release can happen at that point in time. So just know that I'm sure there'll be some learning curve with this new form here, but that's how it is supposed to work and be efficient and allow the parties to make an agreement to terminate, even if they can't agree on the earnest money deposit. All right, moving on. We got new form. Essentially new form 710 here. This is the agency agreement amendment. And you can see here, you pick your agency agreement, but there's been a lot of changes here. So you do have extension, that part's the same, and also listing price, that's the same. But now you also can change firm's fee, you have cooperative compensation, you have dual agency, you can make all those changes with check boxes. This checkbox is gone now. To understand that when we do the editing for these forms changes, we don't have time to do all the final proofing. Like it's just too tight of a turnaround. So that's been changed now. It should be correct in your forms library. So the survival and effective date paragraph does not have a checkbox on it. We want that to be, work every single time. In any event, you can see here, there's a lot of different ways, still a lot of lines to make other amendments to your agency agreement if you wish, but hopefully, especially the addition of dual agency to this form will make it easier to change your designation of dual agency in the transaction. Here we have new form 725, statement of agency relationship and compensation. If you've got somebody who's asking for your agency agreement and you don't want to give it, then this gives you a one-page form to make a representation to a seller or builder or lender or closing attorney about what you're going to be paid. There is a disclaimer at the top making it clear that this doesn't amend anything, but also give you a little bit of warning because if you fill this out incorrectly, then it could be a misrepresentation. So obviously you don't want to do that. Fill it out accurately. But if you got a scenario where you want to be able to tell somebody what you're being paid, if they're demanding that and you're open to telling them, you don't have an obligation to, but hopefully this form will give you a one-page simple way to do that without giving your entire agency agreement over, which to me, I don't like it either as much as you guys don't. So hopefully this is a way to sort of bridge that gap between the request and what you guys feel is prudent as far as the confidentiality of your agency agreements. And then finally, last form for today, and then I'll take a look at the questions that you guys may have. This is new form 804. The offer to purchase a contract, new construction didn't have its own amendment form. Now it does. So you can see here it's got all the same stuff as 4-T, but also the special stuff that is special to 800T, like construction fees and things like that. That is also in here. All right. So let me stop sharing my screen and go over to the chat and see if I got a question. Looks like we got one here. It says, is it possible to have the seller initial lines on the same side on all forms. Um, Potentially same side on all forms. Oh, I see what you're saying. I see what you're saying. You're saying that the seller initial lines are not always on the same side. Okay, well, I I'll tell you what, I'll make a note of that. And I think generally speaking, forms committee loves to have consistency between the forms. So I think that that's something they would definitely be open to. But just as a side note, just so you know, especially in 2T, there's already language in there that says that initials aren't even necessary for an effective contract anyway. So if you got somebody who's really, if initials are a big thing, the initials are really there to make sure that a party can't say, well, I never got that page of the contract, therefore this contract is void. Like that's really what it's there to protect against, is to make sure that people aren't making those kinds of things, those kinds of accusations. All right. Well, I don't see any other questions. And listen, if you think of one later, it's totally cool. You've got the information for the legal hotline. Again, that's legal hotline at ncrealtors.org, or you can call 336-294-1415, and that'll get you to the main office in Greensboro, and they'll transfer you over to the hotline that way. So anyway, thank you very much for having me. Hopefully that'll give you guys a pretty good rundown of the forms changes for this July 1st, and I will see you again next time.